Yes, Indian law allows us right to die with dignity under a right to life. Here's how. Indian law allows passive euthanasia. The meaning of euthanasia is hastening the death of a terminally ill patient in order to reduce his suffering. So, euthanasia is of two types, active and passive. In active euthanasia, some specific steps are taken to cause an end to the patient's life. For example, if a person is suffering from terminal cancer, he might be given a lethal injection so that his life is ended instantaneously and painlessly. Whereas in passive euthanasia, a medical treatment is withdrawn to avoid the continuance of life of the patient. For example, a patient is withdrawn from a ventilator support system so that his life cannot be continued. So, in active euthanasia, something is done to end a person's life, whereas in passive euthanasia, something is not done that could have preserved a patient's life. Active euthanasia is illegal almost everywhere in the world. But the important point to note here is that in passive euthanasia, doctors are not actively killing anyone. They are simply not saving anyone's life. This question came up for consideration before the Supreme Court of India in the case of Aruna Shanbaug, where the victim was raped and she remained in coma for more than 30 years. Her parents were dead, no other relatives were interested in her. So the court allowed withdrawing of life support system. So in such cases, usually such a decision is to be made by the parents or a spouse or any other close relatives of the patient. So the court made it mandatory to take the approval of the High Court before withdrawing any such life support system.